online seminars, and we have another 3 lined up. Next week, no, sorry, in 2 weeks' time, on the 27th of May, Amber and Ernst will be speaking on the reception of Panopticon post Foucault. That will be at 10 AM UK time, and is currently in Canberra. So, you know, depending upon where our speaker is, we change the time of the Bentham seminar. But the next 3 seminars will all be at 10 o'clock UK time. On 10th of June, we have the book launch for the new Bentham the Arts book, which I can show you there. And that is, this book has been edited by my good self. Sorry, I should have introduced myself. I'm Phil Schofield. By Anthony Julius, my colleague at UCL, and by Malcolm Quinn at the University of the Arts, London, with 11 chapters from various contributors. So we're having a launch party on the 10th of June at 10 AM when several of the contributors will speak about their chapters. The book is available now from UCL Press, either in softback or hardback, and can be downloaded free. It's an open access publication, but if you do want to buy a physical copy, either let Tim or me know, and we can send you a 20% form with a 20% discount. So that's that. Then on the 24th of June, there will be a further seminar which we haven't announced yet, but we will announce soon. So we've got, as I say, 3 more seminars. But today, it's great to have David Lieberman, who will be presenting a paper on Bentham courts and democracy. I mean, David hardly needs any introduction. He's been sort of associated with the Bentham project even longer than me, and he did a PhD with Jimmy Burns, the first general editor of the edition, which he completed, I think, back in about 1980. And then, having spent some time at Cambridge, he went to UCL at Berkeley, to the School of Law, where he's been since 1984, and since 2013 he's been Professor of Jurisprudence there. Many of, you know, all Bentham scholars are very familiar with David's wonderful work. His book on legal theory in the 18th century, entitled "The Province of Legislation Determined," is a classic, and he's published a series of articles on Bentham and more widely on British legal history and legal thought in the 18th century. So let's hand over to David for his paper, which I, for one, am very much looking forward to. So, David.
Okay, thank you, Philip, for this invitation, and I hope everybody can now hear me and see me. I need also to thank Tim Causer, who got me switched on to Microsoft Teams and helped in many ways. And finally, I do want to thank everyone who has joined the meeting today. Let's all hope that we very soon can meet face to face, perhaps next summer in August 2021 at the ISIS meeting that Stephen Engelman is organizing for our benefit. Philip suggested that I speak for about 45 minutes, which I'll aim to do. And my presentation today is drawn from a draft paper that I'm happy to share with anyone who would like a copy. And the material itself forms part of a broader study on Bentham's program for representative government set out in his 3-volume Constitutional Code. The Constitutional Code comprised Bentham's most ambitious project during the final decade or so of his life, and comprises his most substantial contribution to political theory. In examining the constitutional program for courts and the judiciary, I shall first explore the prominence that he gave to the judicial part of government in his constitutional program. Secondly, I want to consider the actual program itself and the abuses it was designed to combat. And in a final section, I'll turn to the question of how this program for Bentham related to democratic practices more generally. These questions have perhaps received less attention than I think they deserve, and at least that's what I hope to show in these remarks. Bentham lived in an era of often intense constitutional debate and experimentation. During the period from 1776, that is the year of Bentham's first major publication, to 1832, the year of his death, over 60 constitutions were enacted in the European states and many more proposed and debated. In North America, where Bentham followed developments closely, by 1832, the 24 US states had enacted 34 different constitutions. Bentham's own constitution had many novel features, not least its terminology and its form of exposition, but among the novelties was the exceptional amount of space that he devoted to courts and judicial procedure. The bulk of the final volume of the code set out in lavish detail the program for what he termed judiciary establishment. This comprised nearly a third of the code itself, greater space than he devoted to the elected legislature or to the substantial administrative structure under the prime minister. This distribution of attention, moreover, was quite exceptional. Far more typical was the influential example of the original Constitution of France, enacted in 1791 by the Revolutionary National Assembly. There, the presentation of the judicial branch took up roughly 16% of the Constitution's provisions. In other words, about half the space that Bentham committed in his constitutional program. Thus, the first question to consider is why Bentham gave such priority to this area of government, why he came to see this area as so critical to the success of a democracy in advancing the greatest happiness of the community. There are obvious and important biographical dimensions to this story. The decade in the composition of the code saw renewed attention to law reform in contemporary England. Selective reform of the criminal law had been undertaken in the decade under the management of Sir Robert Peel. In 1824, a royal commission was appointed to consider long-established complaints concerning the costs and delays in the Court of Chancery. In 1828, the Whig politician and future Lord Chancellor Henry Brougham delivered a 6-hour speech to the House of Commons, which, among other items, identified numerous areas of court and procedure reform for the consideration of the British legislature. Bentham moved promptly to take advantage of the opportunities these initiatives created, publishing a series of polemics and pamphlets to advance long-favored institutional design. Philip Schofield surveyed these writings in the penultimate chapter of Utility and Democracy, and more recently, Chris Riley published a pair of important articles on 2 of these understudied compositions. Among them were 2 lengthy and unforgiving critiques of the entrenched abuses in English courts and legal process, the 1825 indications respecting Lord Eldon, and the 1829 justice and codification petitions. His 1830 Lord Brougham displayed set out a scathing condemnation of Brougham, now Lord Chancellor's proposal for reform of equity jurisprudence and the establishment of new bankruptcy courts. The Equity Dispatch proposal, published that same year, offered litigants a cheap and speedy alternative to adjudication under England's equity courts. All these works enjoyed a close relationship to the Constitutional Code, to which Bentham himself drew attention. His attack on chancery practice under Lord Eldon, featured in the 1830 collection Official Aptitude Maximize, Expense Minimize, which Bentham presented as a companion to the Constitutional Code. Indications concerning Lord Eldon, the Justice and Codification petitions, the Equity Dispatch Court proposal were each referenced in the Constitutional Code, along with earlier writings on court reform. The Justice petitions contained a brief summary of the lengthy judicial plan elaborated in the Code. By the time of Lord Brougham displayed, much of the Code was actually in print, and Bentham invoked the Code directly for the institutional principles in terms of which he denounced the sham reform measures proposed by Brougham. The harsh critique then concluded with lengthy extracts from the Code's own treatment of judiciaries collectively. But even without the unique reform opportunities of the 1820s, this was a field of government practice that long occupied Bentham's attention. As early as the 1789 preface to IPML, Bentham recognized that his codification program included legislation in matters of procedure. The Procedure Code reappeared in the preface to the published first volume of the Constitutional Code, where Bentham promised soon to publish a Procedure Code table to accompany the constitutional plan. Bentham's single most ambitious contribution to legal theory, the 1827 Rationale of Judicial Evidence, edited by the young John Stuart Mill, addressed the related topic of legal evidence. The plan for the judiciary establishment in the Constitutional Code thus drew on a unique fund of reflection on courts and their appropriate operations. Indeed, if Bentham is placed within the company of other famous designers of and advocates for republican constitutions of his era, theorists to whom Bentham
David, we've lost your microphone. So, David, we've lost your microphone.
Can you hear me now?
Yeah. Would you just back a couple of sentences, please?
Okay.
While I'm on Yasunori, would you turn your camera off, please?
Okay. Should I go, Philip?
Yeah, I can hear you now. Thank you.
Thanks. Sorry about that, everyone. The plan for the judiciary establishment in the Constitutional Code drew thus upon a unique fund of reflection on courts and their appropriate operations. Indeed, if Bentham is placed within the company of other famous designers of and advocates for republican constitutions in his own era, such canonical figures as Rousseau, Sieyès, Paine, Condorcet, Madison, and Godwin, he was unique in coming to constitutional creation following such a prolonged engagement with this particular branch of public authority. Now, let me turn to the plan for the judiciary itself. His express aim was to secure justice and thereby realize the benefits and securities of the law for every member of the community. To achieve this, courts needed to defeat the twin failings of misdecision, that is, an incorrect application of the law, and non-decision, that is, a failure to apply the law. The avoidance of these failures, in turn, required the minimization of what Bentham famously referred to as expense, vexation, and delay. These goals implicated broad elements of Bentham's entire codification program, well beyond his discussion of courts and procedure. With regard to the institutions of justice, Bentham proposed a network of local courts, styled immediate judicatories, operating under the authority of a justice minister appointed by the elected legislature. The immediate courts exercised what Bentham termed universal jurisdiction, handling all the disputes that were brought before them, irrespective of their subject matter or monetary value. These were publicly financed tribunals, staffed by salaried officials, and available to members of the community without charge or fees. They provided uninterrupted service, functioning all times of the day and night as circumstances required. And they were distributed in sufficient number so as to be accessible within a single day journey by foot by every member of the community. Allowing 6 hours for the completion of a typical case, Bentham enthused that, quote, a grown person in a state of ordinary health and strength could activate the court and secure judgment in the course of any day of 24 hours without sleeping elsewhere than at home. As important as the universality and proximity of these tribunals were the procedures and personnel through which they operated. Each was headed by a single appointed judge and an administrative arrangement that embodied the principle of single-seatedness, which operated standardly through the code. The immediate judge, moreover, exercised extensive investigatory powers and procedural discretion through a process of adjudication Bentham referred to as natural or summary procedure. The individual judge took responsibility for collecting and receiving evidence and for interrogating litigants and witnesses. Information, arguments, and responses were presented orally by the suitors themselves and directly to the judge. Each court was furnished with a small number of salaried officials, among them advocates representing the government, as well as advocates to advise and assist litigants. However, the institution was purposely designed to eliminate the need for and costs of professional representation, and there were no restrictions on the kinds of evidence and testimony the court could receive. The direct participation of the litigants and the procedural discretion of the judge for Bentham served the interests of a speedy resolution as well as accurate decision. Given the multitude of the immediate courts throughout the country and the procedural discretion enjoyed by each immediate judge, Bentham turned to the instrument of publicity to ensure the integrity and rectitude of the institution's processes and decisions. Publicity, of course, operated throughout the constitutional code as a generic and critical resource against the abuse of power. In the case of the judiciary, Bentham believed that publicity functioned with special efficacy. Publicity is the very soul of justice, Bentham explained to the legislators of France in 1790, and he reaffirmed these sentiments in the Constitutional Code. As he put it, only in proportion as publicity has place can any of the checks applicable to judicial injustice operate. Where there is no publicity, there is no justice. Single-seatedness, while reducing public costs in the form of judicial salaries, at the same time intensified the responsibility and the resulting accountability of the individual judge. The immediate courts operated as open tribunals specifically designed to accommodate outside observers and government monitors. A mandated system of detailed and official records ensured that the conduct of each judge was available to the supervising justice ministry and the elected legislators. Among the many devices Bentham deployed to intensify publicity was a novel institution styled the quasi-jury. Composed of 3 members and drawn locally from a large pool of eligible voters, the quasi-jury functioned as a mandatory court observer, passing judgment on the conduct of the case and especially on the conduct of the judge. The body operated by majority voting. Where the quasi-jury disagreed with the decision of the judge, such disagreement would immediately trigger a review procedure. Where one member of the quasi-jury disagreed with the decision of the judge, a report of the dissent was included in the official record of the case. Like the political press, the quasi-jury comprised an instantiation of democracy's public opinion tribunal. As was the case throughout the Constitutional Code, Bentham's constructive program was accompanied by a running polemic against the abuses of existing practices. In this case, the vices Bentham denounced as the technical system of legal procedure. The dramatic contrast between the defects of technical procedure and the corrective merits of natural procedure figured standardly in Bentham's earlier writings on court reform. But here the reform polemics of the 1820s, to which I referred earlier, are particularly relevant and instructive. The 1829 Justice and Codification petitions, for example, delineated at an enraged length the shocking failures of justice perpetuated through the long entrenched system of technical procedures. As he insisted in the Constitutional Code, the ordering logic of current arrangements all derive from the practice of court and professional fees, which directly tied the power and material welfare of judges and lawyers to the costs and requirements of the legal process. Rather than aiming at justice, the technical system aimed at the wealth, power, and corrupting interests of judge and company. One thing throughout is intelligible, Bentham thundered. At the bottom of everything are fees. And the cumulative product of the fee-fed judge and company was a monstrous labyrinth of expense, vexation, and delay that masqueraded as justice. Bentham described 14 distinct devices that sustained and magnified the failings of the unreformed system. An unwritten and unknowable body of judge-made common law, arcane terminology, feigned legal actions, stylized legal pleadings, and exacting court protocols, as well as extensive reliance on legal fictions, created an unintelligible legal order in which the vindication of legal right necessarily required the assistance of lawyers and court officials, each charging fees for their services. The search for fees and opportunities to charge litigants inflated the numbers of officials, tribunals, judges, and jurisdictions, as well as the required stages and forms of legal process. Rules that barred litigants from presenting their own cases in court enabled and multiplied technical rules of evidence, which required the submission of lengthy, costly, and duplicative documents, and which in turn created new opportunities for exacting fees. Restricted law terms and limited court sittings extended delays and thereby increased vexation. The multiplication of courts meant that the same legal dispute might be bandied from court to court, each court utilizing different procedures and rules of evidence, and each requiring new submissions and pleadings, and every step adding further layers of expense and delay. A property dispute appearing before the high courts of common law, Bentham reported, under the most favorable circumstances, might cost upwards of £30 or even hundreds of pounds. When a property dispute moved by appeal from court to court, the costs were raised to thousands of pounds. And when a case came before the equity courts, the cost inflated to little, if anything short of 10,000s of pounds. Had the case instead been treating according to what Bentham termed a mode of procedure really aiming at justice, that is, the alternative natural procedure, quote, the suit would have been heard and determined without any expense in the shape of money and at inconsiderable expense in the shape of time. For Bentham, the damage caused by the abuses of the unreformed legal order went well beyond the crippling and unnecessary expense, vexation, and delay it inflicted upon litigants. Two particular consequences received emphasis and regular condemnation. First, the costs of litigation turned the legal order into a weapon the wealthy could use against those lacking comparable resources. What determined whether to pursue litigation was less the merits of the legal claim than the resources that could be brought to bear against an opponent. The legal order became what Bentham styled a graduated system of depredation and oppression, in which each social rank enjoyed dominion over those below it. Second, the expense of litigation simply placed justice beyond the means of the vast majority of the population. For the immense many, as Bentham styled them, who could not afford to pursue a meritorious legal claim, justice remained simply unavailable. Quote, be the pay in each instance but a farthing, he claimed, to all that cannot pay the farthing, justice is denied. In direct contrast, Bentham emphasized that the constitutional code for the first time furnished to every man alike, insofar as may be, the protection of the law by means of the appropriate services of functionaries in justice employed by the state for that purpose. This priority that the institutions of justice reach all the members of the community extended well beyond the geographic placement of local courts and the free and prompt adjudication the courts delivered. Bentham identified important additional measures to support those whom justice was currently denied. Litigants had available to them a new official, a special advocate, who provided legal advice and representation to those unable to afford private counsel. Among the measures to ensure justice for the hapless was the creation of a publicly financed equal justice fund to assist with the expenses associated with litigation and to help mitigate the imbalance between two litigants occupying different stations in the scale of opulence. Perhaps most intriguing were the efforts to insulate courts and judges from the corrupting influence of the legal profession. The Constitutional Code severed the professional connections between elite bar and bench by treating professional legal practice as disqualifying for judicial service, repudiating the well-established English convention that distinction as a barrister provided proper qualification for elevation to the bench. Bentham emphasized the very different tasks and values appropriate for each role. Talented lawyers inevitably pursued wealthy clients whose interests they were hired to advance. Successful lawyering, Bentham maintained, came to those, quote, who have been for the longest time habituated to the practice of profit-seeking and profit-reaping mendacity. And these were precisely the qualities that proved disastrous in the office of the judge. Here, the commitment to justice and the general welfare of the entire community was paramount. Unlike the fee-fed advocate, the Benthamic judge publicly declared, quote, not to bestow less attention upon the causes of the poor than of the rich. In the language of modern law, Bentham's constitutional program thus gave overwhelming priority to matters of legal access, legal aid, and equal justice. But how precisely did these goals serve specifically democratic interests? The question has important place in contemporary political theory and constitutional jurisprudence, where access to justice is routinely taken to be fundamental to democratic legitimacy and to serve democratic core ideals. In Bentham's case, the question has a different and distinct salience. The Constitutional Code furnished a setting for the constructive elaboration of the institutions of justice. But the contents of the plan itself, as Philip Schofield rightly emphasized, built explicitly on materials that had been assembled earlier, in the decades well before he embraced the cause of democratic reform. These pre-radical treatments of courts and procedure and evidence comprised writings that Bentham explicitly continued to cite in his mature constitutional plan, though obviously none of these earlier plans made a connection with democracy or representative government. Bentham, I believe, did see important democratic dimensions to his judiciary plan of the Constitutional Code. Nonetheless, these connections require some elaboration, as this was not an instance in which political radicalism led to a revamping of a previously developed law reform program. As occurred in many other instances, indeed, as I would argue was typically the case, political radicalism did not transform the content of Bentham's codification program. Instead, radicalism led Bentham to recognize and emphasize the democratic promise of what was already there. Here, it is important to keep in mind the basic contours of Bentham's democratic commitments. And as will follow, my reading of these commitments closely follows Philip Schofield's influential account in Utility and Democracy. Like many of the Democrats of Bentham's era, such as Sayers and Paine, Bentham arrived at democracy through a critique of monarchy and aristocracy. All political systems, he maintained, divided the community between the ruling few and the subject many. In the unreformed states of Europe and their colonial outposts, the ruling few comprised an entrenched set of elites that controlled the power and resources of the state to advance their own sectional interests at the expense of the general interests. It was this structured and pervasive sacrifice of the general interests of the community that rendered these forms of political rule a system of sinister interests. Courts in the legal order supplied Bentham with a leading institutional instantiation of sinister interests and the tyranny of the elite minorities. As we have seen, the leading defects of the law could all be ascribed to the professional interests of judges and practitioners. Under the incentives of the fee-gathering system, judges and lawyers had every incentive to maintain and amplify expense, vexation, and delay, since such conduct was the route to wealth and power. To choose to abandon the technical system and instead genuinely advance the goal of substantive justice required a sacrifice of wealth and power for the sake of the welfare of the entire community. Such a sacrifice of personal interest was entirely possible at the individual level. Nonetheless, the overwhelming failings of current law made evident the utter folly of relying on this kind of sacrifice at the level of institutional design. Bentham's court designs and natural procedure, in contrast, created structures through which the interests of those who dispense justice were aligned with the interests of the entire community. The elimination of fees deprived judges and court officials of the opportunity to use adjudication as a means to material profit. Litigants face no geographic, financial obstacles to pursue valid claims of legal right. The relentless mechanisms of intense publicity, direct accountability, and the censorial eye of the quasi-jury gave every encouragement to the rectitude of decision-making. The judge preserved his office and enhanced his reputation by extending justice and thereby the securities provided by law to the entire community for their welfare and general happiness. Bentham's constitutional code and final set of law reform polemics thus supplied a democratic gloss on reforms that predated the embrace on political radicalism. A further democratic dimension was found in Bentham's increasing emphasis on how the sinister interests of judge and company operated within the larger field of the unreformed British state. In this context, Bentham's fierce attack on Lord Chancellor Eldon, presented in the 1825 Indications, is especially revealing. By the 1820s, the Court of Chancery and English equity jurisprudence were long favored targets of reformers of English law. Eldon's long chancellorship was particularly associated with the endless delays, and exorbitant costs of chancery adjudication. By the mid-1820s, critics of chancery increasingly focused their attacks on the person of Eldon. Bentham enthusiastically joined the campaign, but his special focus in the Indications was the corrupt political structures that enabled Eldon to exploit so ruthlessly the power and material benefits of his office. In this, Eldon provided a perfect target for Bentham's purposes. As Lord Chancellor, Eldon occupied the highest position in the hierarchy of English central courts, but the chancellorship was a major political position, a ministerial official who presided over the House of Lords in both its legislative and judicial capacity. As a member of a succession of ministries and cabinets, Eldon successfully helped to obstruct parliamentary proposals for political and legal reform through the 1810s and 20s. When a royal commission was established in the mid-1820s to investigate chancery and recommend improvements, Eldon was appointed its nominal head. As Bentham scathingly observed of the arrangement, quote, "It was by Lord Eldon that His Majesty was advised to commission Lord Eldon to report upon the conduct of Lord Eldon." Eldon's chancellorship displayed a particularly flagrant demonstration of the manner in which justice in Britain had been hijacked by the material interests of the judge and company. In the face of mounting complaints against oppressive court fees, Lord Eldon simply went to Parliament, as Bentham put it, and in 1822 secured a statute authorizing the judges of England's highest courts to regulate fees in their own respective tribunals. England's courts applied the laws of treason and seditious libel to protect the political establishment from radical critique, and Parliament returned the favor by sanctioning fee gathering. Whereas a British Parliament would never dare to raise taxes without the authority of legislation, judges were authorized to tax suitors in the absence of public scrutiny. As Bentham insisted, quote, suppose that judges would have for the end of action the happiness of suitors, as well might you suppose that it is for the happiness of Negroes that planters have all along been flogging Negroes, for the good of Hindus that the Leadenhall Street proprietors, that is the directors of the East India Company, have all along been squeezing and excoriating the 60 or 100 millions of Hindus. Bentham's embrace of representative government left in place an earlier diagnosis concerning the causes and function of the prevailing abuses he found in the existing system of common law and the system of technical procedure. Likewise, it left largely in place the institutional antidote he found in codification, accessible courts, and natural procedure. Political radicalism, however, supplied a political deepening of the analysis. The rent-seeking conduct of Judge and Company now figured as one of several privileged elites who commandeered the institutions of the state to enhance their wealth, power, and sectional interests. The advocated network of reform court and reform procedures, advancing the welfare of the entire community, were now understood to serve a universal and democratic interests. Bentham's constructive program for the judiciary establishment, moreover, reveals particularly well the extent to which his constitutional program sought to increase the happiness of the community by extending and thereby increasing the benefits of law and public authority throughout all members of the community. For the first time, legal securities would be enjoyed by the entire community, and especially by those whose lack of wealth previously rendered them the victims rather than the beneficiaries of the institutions of justice. The goals of equal justice and legal access themselves that Bentham emphasized in the program were, of course, scarcely novel. Bentham himself liked to invoke Magna Carta to condemn the sale of justice. The constitutions of his own era standardly promised, and here I quote the language of the 1780 Constitution of Massachusetts, that, quote, every subject ought to obtain right and justice freely and without being obliged to purchase it, completely and without any denial, promptly and without delay, conformably to the laws. Yet if the goal of free and accessible justice was unexceptional, the attention and care Bentham gave to its institutional realization was unique. The exceptional size, specificity, and detail of Bentham's plan for the judiciary establishment in the Constitutional Code can be taken as telling evidence of the amount of public resource and political commitment he recognized equal and accessible justice so urgently demanded. So thank you very much, and I'm looking forward to your comments and questions.
That's great. Many thanks indeed, David. Just a little reminder that if you'd like to ask a question, you can either do so through the meeting chat, which if you hover on your screen, you will find an icon like a speech bubble, the third one from the right. That's how to turn on the chat if you haven't done so already. But if you'd like to ask a question, please just flag that up in the chat, and then I will bring you in. You can turn your microphone and your camera on and ask the question. We've already got one question from Dilip Sharma. I don't know if you can see the chat, David, but the question there is, how far is Bentham's idea of an independent, unbiased public court system true in the present modern era? I don't know if you've, I mean, we should, I shall make your excuses as a historian, David, straight away, but I know you've given this paper to lawyers elsewhere, and I don't know if you've got any reflections on whether Bentham's ideas are still helpful or useful.
Well, thank you. It's a telling question, obviously, and I don't have a definitive response, but here's my instinct. I think that, and I may, in responding, I may be guilty of the provincialism that comes from my US vantage point. So I apologize. Certainly, a lot of the specific reforms, particularly the idea that there needs to be a public fund to support poor litigants, that there needs to be a kind of procedure that puts the costs of adjudication, that makes adjudication available, that there should be special professionals devoted to the causes of the poor. All this has become a standard part of the way in which modern states, North America, but also in Europe, try to accommodate the needs for legal access and equal justice. But I think, to me, in my mind, the most important of the insights here is the simple recognition that the great failures of justice in our society are the result of poverty and lack of material means. Bentham denies courts a great deal of the constitutional function we now associate with liberal constitutionalism. The courts are not vindicating constitutional rights in a manner that has become familiar. However, I think the Bentham response, and I think it's an important response, is the great failures of justice have little to do with fundamental questions of constitutional rectitude. Rather, they have to deal with questions of access. And I think his whole design is drawing attention to that priority.
Thanks, David. And a comment from Robin Jacob about the abolition of judges' fees. I've got it in mind that Peel, I remember annotating this for a fee slap to maximise that Peel brought in a measure to in the 1820s to turn fees into salaries. Though I can't remember how far that measure went. Can you?
So that's absolutely right. That, if you like, Bentham is following or adhering to an increasing emphasis on the need to control fees and to replace the structure of fees with a structure of salaries. This is found throughout the kind of system of court structures in England, in which courts, particularly in the localities, through entities like individual magistrates and quarter sessions, are exercising both administrative as well as judicial functions. So the general drift is towards salaries, though the complete abolition of fees and replacement of salaries, I don't think occurs until the mid-century Victorian reforms. The situation in the 1820s and 30s is more to contain fees and to supplement fees with salaries, but I'd need to double check all that to make sure that occurs.
Yeah, thanks, David. Anyone would like to ask questions? Please feel free to do so. While people are thinking up questions, this may be a little, well, no, it's not unfair, but it's not something you addressed directly, but I'm sure it's something you thought about. Jerry Posthumer, in his reissue of, well, I hope Jerry's not with us. If he is, he can put this for himself. But in his reissue of Bentham and the Common Law Tradition, in the supplementary chapter, sort of defends his position in relation to the role of judges and whether the judges should. Jury made the argument that judges were to act as in that utilitarian fashion, that the law was rules of thumb, which but they were to take each case on its merits. And jury's position's been criticised, first of all, by John Dinwiddie, then by Francesca Ferreira, saying that in fact, if you look at constitutional codes, judges were definitely not allowed to make up the law themselves. So that was sort of returning to the common law position, but that there were mechanisms in place for them to for them to suggest law reform to the legislature, who would actually enact any changes. I mean, what's your view on that debate, David?
So, in general, I support the detractors of the critics of Jerry Posthumer's position. Bentham, I think, in the Constitutional Code was very clear that judicial decision-making was not to become a source of law, and that alternative mechanisms needed to be utilized for problems in the existing substantive law to be addressed only by the legislature. I think the challenge that Jerry's work emphasized, and which Bentham was interested in, was the extent to which the fidelity to the code by a judge might lead to decisions that were contrary to the happiness of the litigants and therefore to the broader welfare of the community. What I think that account doesn't emphasize enough is for Bentham the absolute menace of judicial and innovation, again, as a source of law in the community. I find very striking that the first thing Bentham discusses in introducing the Constitutional Code is the idea of codification itself and the program of codification, and that the code is but a branch of codification, that is a authoritative rational, coherent, systematic body of law which will guide all the members of the community and certainly officials in the community.
Yeah, thanks. So we've got a couple of questions have come up. The first one from Sadia. I'll read it out. In Bentham's view of utilitarianism and the idea that the poor do not receive justice as a result of lack of monetary resources, could it be said he recognised the poor only because of the fact they were the majority over a minority of wealthier individuals, or would he recognise them if they were the minority versus a wealthier majority? That's an interesting question.
That is.
Yeah.
So certainly, Bentham, if I take, that's a really good question, and it's articulated well. And I'm not sure how to answer it. In general, Bentham is aware of the problem of the relationship between the majority interest and the general happiness of the community. And he discusses or identifies places in which there are entrenched, if you like, animosities amongst the members of the community, such that majority rule poses particular danger. This would be the division, for example, between Protestants and Catholics in Ireland. Where I think this question would probably be answered in Bentham is not in the democratic writings, but in the political economy. Bentham simply took it for granted that most of the society would be what he defined as poor. That is, comprising individuals who had to labor, who had to work in order to satisfy subsistence, and that condition went way up, quite high up the social scale. The poor were distinguished from paupers, that is, the people who would not maintain their own subsistence even with labor. And those people needed special help, and I think those people were a minority. However, since most people had to labor in order to satisfy basic material needs, providing access to the institutions of justice to vindicate legal security and legal rights would be something that would be a benefit for the vast majority of the population. So the kind of conflict between the majority and the minority interests, I think, simply would not arise. It's beyond Bentham's imagination to imagine a distribution of wealth in any other terms.
Okay, yeah, thank you, David, and thanks for that question, which sort of relates to the wider ramifications, I suppose, about utilitarian attitudes to minorities. But Peter Neeson has a question, which I'll read out, and he has a question about the origin of the idea of quasi-juries in democratic education. As you say, they are seen by Bentham not only as a check on judges, but also as a school of justice. Peter says he doesn't know how far back the idea of quasi-juries goes in Bentham's works, but he's seen him develop it with regard to a colonial context in British India, where he thinks most natives, as he calls them, could not be trusted with jury service. The formulation of a school of justice comes up there too, printing the Principles of Judicial Procedure of 1827. Do you think Bentham's shift to recommending quasi-jury duties instead of jury duties has this background in his conception of social education?
Right. Well, Philip, you might need to help me out about when.
You know what? I was just thinking, I'm glad you're being asked this question and not me. I don't know if Peter wants to come in and just give us a bit more background, because I didn't know about this. Is Peter?
Yeah, I'm here, Philip. Can you hear me?
Yes, we can. Yes.
Hi, David. Hi, Philip. Hi, everybody. Unfortunately, I don't know much more than I've written down in the question.
So I inflicted on Peter the written version of this paper, and that does include a longer discussion of the quasi-jury, and particularly this emphasis that the quasi-jury functions as what Bentham calls a school of justice. That is as a training ground for the members of the community in understanding the institutions of justice and the law, and indeed as a training for acting as officials within the institutions of local government, including officials within the intermediary courts. I'm not sure when the quasi-jury first emerges in Bentham's writings. It does, I think, follow from a long analysis, a kind of prolonged discussion of the merits and defects of the traditional common law jury. In some ways, the quasi-jury is a distillation of what he thinks is beneficial about the traditional common law jury and the elimination of the things he finds is deeply faulty. In the constitutional code, as opposed to the situation in British India, about which I'm afraid I'm embarrassed to say I don't know, Bentham certainly says that the quasi-jury will be drawn from the large pool of the electorate as defined by the code according to a very generous franchise. So I think he does think the membership of this quasi-jury will include individuals of all ranks. Indeed, there's a passage I dimly recall where he talks about perhaps the need for special dress, outfits, costumes for the members of the quasi-jury so that their poverty could be disguised in the operation of court so that they wouldn't come to be disdained based on what they wore in the outside world and the like. So I think he sees it as a very democratic body, and he emphasizes that, you know, the members of the quasi-jury are to be paid and that their service as quasi-juries is mandatory when called upon to serve. So I think he sees this as a very general obligation by the community. It's interesting. I mean, there is this well-established orthodoxy that I'm supposing he embraces, that individuals in India, particularly in their dealings with the legal system, could not be relied upon in terms of their integrity and their honesty. This comes up again and again in dealing with legal officials, legal practitioners in India. I would need to look much more carefully at the materials that you're drawing my attention to know for sure. But I think, if you like, my answer is there seems to be a considerable gap between what he's saying in the context of India and what he's saying in the constitutional code. The other thing that I'm just reminded of is that this idea of educating the members of the community about the law in that way of providing a school of justice for the community appears very early in the codification writings. Already in that long letter he writes after completing the work that becomes On the Limits of the Penal Branch, he says that among the uses of the work is to educate the entire community about the laws under which they operate, and that thereby codification has an educative function for all the members of the society.
I mean, it's worth also saying that principles of judicial procedure, one of the advantages of the online seminar, I can just go and pick a book up off the shelves. I've got the Chuo catalogue here. Of course, it was edited for the Bowring edition by Richard Dawn in 1837. And it says here from manuscripts written mainly between 1820 and 1827. So one would have really to go into the manuscripts and just see where, what where the particular passages have been gleaned from and how Dawn had cobbled them together for that particular work. Moving on to Stephen Engelman's question, he asks, should we look to personal biography, intellectual biography, or elsewhere to account for Bentham's early suspicion of lawyers and judges in comparison to other sectional interests, public authorities, who were often given the benefit of the doubt prior to his radical period?
So again, this is something where I think others who are participating today also will have thoughts, and they may be better informed than mine. There is, I'm often tempted to think that, and I'm sure if I think it, it's because Philip somewhere has written this down. I've been so influenced as to imagine it's my own independent original thought. But Bentham, as early as the Critique of Blackstone, if not earlier, sees that the defects of English law work to the advantage of the profession. That, in terms of the fragment, that the fundamental blemish of Blackstone is antipathy to Reformation. And it's tempting then to imagine that the account of sinister interests is generalizing from the particular diagnosis of the manner in which the abuses of an institution, in this case, the abuses of English law, are the product of the machinations and practices of the sectional interests, that is, judging company, as it's later called, who benefit from these abuses. Instead, we have a whole system of elites, including hereditary nobility, the imperial project, the military establishment, and perhaps above all, the Church of England, which is contributing and operating in similar terms. So in that way, one could say that, it all has to do with the antipathy to lawyers and to this insistence on the way they behave. That being said, I also tend to think, and here I kind of don't have the courage of this sentiment, that of all the groups, of all the elites that Bentham portrays and condemns as a sinister interest, the critique is most effective with regard to judge and company. I don't often in these writings he identifies sets of elites who have to be condemned, But then it seems to me the actual critiques operate most vehemently and effectively in the case of lawyers. So in some ways, I'm fixated on Bentham as law reformer rather than social reformer, political reformer, and I'm projecting that perspective onto his democratic advocacy.
Right. The next question from Megan sort of follows up on what you've just said. Megan says, I'm wondering about the way in which Bentham's more general reliance on publicity as a technique for countering sinister interests seems to have been sharpened in his works on the legal system. Would it be right to say that it is in the legal critique that we see the most multidimensional thinking on publicity? Not only visual access to proceedings, availability of records, etc., but concerns with intelligibility of concepts and vocabulary. And might this in itself be a contribution to the workings of democracy?
I feel like saying amen. I mean, I think that nails a great deal. And this is, in many ways, just to gloss the points you make very effectively with some additional, less effective observations. Thanks to Foucault, and we'll hear more about this, I guess, in 2 weeks' time, but one is, I think we're all familiar now with the manner in which Bentham thought of surveillance, as Foucault would have it, inspection, as Bentham would have it, as a resource to combat the abuse of power, as a resource to ensure appropriate conduct. And there are many places in the code, constitutional code, where he insists on inspection doing that kind of work. There are many, if you like, panopticon architectural devices specified for the practice of government, including the practice of courts. But what I think is often neglected in this emphasis on Bentham on surveillance and inspection as a resource is the additional emphasis he gave on reason giving, the requirement to explain behavior, conduct, decisions as a further resource, an additional resource, an important resource against the abuse of power, which could operate in many settings where visual inspection just couldn't apply. And this reason-given requirement and the way in which it directed power in a manner that limited abuse or potentially limited abuse was hard-baked into the codification program. Bentham repeatedly says making laws is one difficult challenge, but far more difficult is the need to provide the code with what he calls the perpetual commentary of reasons that explains its provisions. And I think that directly feeds into the emphasis Megan's question rightfully points to, this emphasis on publicity and the many dimensions of publicity. Publicity, reason given, makes the law, the institutions of government more effective and thereby more powerful, but it also constrains the institutions by forcing them always to explain themselves to those affected by public authority and public institutions.
Thanks, David. Are there any other questions or comments? If not, I think we should give unfortunately one can clap, but David can't hear us. But
even worse, you can't take me out for a drink.
No, I know. Well, actually, I was thinking that was one of the advantages of these online seminars. Sits at one desk and doesn't have to bother with the speakers, you know. No, seriously, it would have been a pleasure to have taken you out for a drink and meal. In fact, we were expecting David to come and spend some time at UCL this spring, and so we'd actually fixed up a Bentham seminar in UCL for around about this time. I think it might have even been today. So at least we've got our seminar, and the advantage is probably 3 times as many people has listened to it as we would have done if we'd have had you in the flesh. So thank you so much for that, David. Really interesting to see the way in which you've linked Dr. Bentham's criticisms of the common law to his democratic proposal, to the proposals he put forward in his democratic writings in relation to the judicial establishment, in order to obviate, solve those problems in the common law. So when will we see this paper published?
Well, actually, I mean, one destination is that collection that you and Shai Boget are producing or editing or proposing for papers on the constitutional code. And I don't know where that project is at the moment. I need to figure out, I see a question from Sadia about getting access to the paper, and I don't know whether there's a way. I'll talk to Tim, perhaps, exploiting Tim's technical.
Sorry, Sadia, I'm not sure which papers do you mean? Anyway, well, yeah. If Sadia can email Tim or me, and just to clarify that will be fine. Sorry, David.
No, just to say that there must be a way I can post the draft written version, longer draft written version of the paper, and I'll be delighted to do so.